come in and watch people. Oh, you can watch them and we'll pay you $10 an hour. And then other things ended up happening. There's no way you should be in charge of caring for anybody because you have a temper that you cannot. All right, court is calling 2025. CR 001442 State versus Patricia Adams. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense.
Michael DeLeon for Ms. Adams.
And are you Patricia Adams?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Adams, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, family, household, or member with a previous assault conviction? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Adams, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your plea? Defense, is that the plea?
That's correct. Your
State,
Honor.
is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No motions, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years, 150 hours of community service restitution, the HMAC, and TAP evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? All right, what is HMAC?
Hostility Management Area Control.
All right, people love their acronyms, right?
In speaking with probation, I probably should have spelled it out.
No. I always like to know.
I didn't know what it was either, Your Honor.
Okay,
If we want to go off record real quick, I can probably.
I'm sorry.
If we want to go off record real quick, I can probably explain what it is to answer.
Oh, no, I know what the anger and hostility course is. I just didn't know those were that was the acronym.
Okay.
So-
Okay.
All right. My motto is always, if you don't know something, ask. I always tell my students, what's a dumb question is not asking, is the unasked question. Everything else, we're finding out information. So I've learned something new today. All right, so to the offenses charge, how do you plea?
No contest.
All right, state any evidence?
Yes, Your Honor. At this time, state offers into evidence State's Exhibit 1 with all attachments.
Any objection?
No objection, Your Honor.
All right, and state, have you spoken with the complainant?
We've attempted to, Your Honor.
All right, state, you may be excused. Thank you very much.
Thank you.
And state, you can be excused. This is the last case we have for today. All right, thank you. All right, did you review the document entitled Waiver and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? This court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor. I do have one ask.
Yes.
Ms. Adams is in yellow because she recently had a baby a month ago at the
Mhm.
jail. So she's currently not working right now. We were wondering if the court would be consider probating any of that fine, 1,500. That was my big ask because she's getting back on her feet as far as, when she's out. And we're asking the court to grant her application for deferred and to allow her to do the TAP evaluation outside of jail.
All right, I'll probate the entire fine. So here's my question. I read this police report. Why are you hitting on your mom?
Your Honor, it was honestly, she assaulted my dad and I kind of acted on fear, heard my dad screaming, so that's the reason why I kind of assaulted my mom.
Well, that's not kind of, and it doesn't
Well, I
mention that in
accept it.
here. And what, your father, is that Mr. Adams?
Yes.
All right, that's not what he says in this police report.
Well, that's what happened in the true situation.
Why are you living with them?
At the time I was staying with them because my dad had lost his Social Security and my mom was the only one that had Social Security. And I was trying to be my dad's provider. So that was that situation and, money became a argument in that.
No, that's not what she's saying. She's saying you wanted to lay in bed with her. And she said no.
Your Honor, I have my own air mattress. I didn't have to lay with my mom.
So, I mean, do you want a jury trial? Because it's sounding like counsel, she's saying none of this is true because in the report, it says that your mother had a swollen, busted, and bloody lip, that the officer immediately noticed it. She declined medical attention, and she stated that you had been staying at the motel with them. Victim states that you and her do not get along. It says that you went to lay in the same bed as the victim, and the victim told you to get up and move, and that caused an argument. Victim stated that she attempted to leave the location multiple times, but the suspect, that's you, was not allowing her to walk out the room. Suspect pushed victim multiple times away from the door, then punched her in the face one time with a closed fist. Suspect then grabs the witness's cell phone from the bed and fled the location. Witness 1 witnessed the assault and stated that suspect did push the victim and punch her in the face. Witness is disabled and bedridden. Victim provided information on suspect, and after running her information through CAD, it was determined she had a prior conviction of family violence. Then, are you saying that you didn't take your father's cell phone?
It was mine and I had literally just got paid that day. So that's the only reason why I took my phone back.
All right, they're saying it's his phone because they said, I contacted the suspect over the phone with the phone number provided that was witness's cell phone. And it says, you state, I'm not coming back to the location and I did not assault the victim. And it says in here that you told them that the victim purposely hit herself to make it look like she was assaulted. And now you're telling me something different.
I didn't call on saying that she hit herself. I
That's-
admitted to the police officer on the phone that I did assault.
No, that's not what this says, unless you're telling me the police officer just like, let me make something up in this story and put in here that she said she never hit her and that the victim hit themselves.
Judge, I've had extensive conversations with Ms. Adams about the particular situation. And while there's some dispute about the factual situation, overall, what it boils down to, and Ms. Adams agrees, is that she did hit her mother. That did occur. Circumstances around it are a little fluid, but overall, she does want the court to proceed with deferred adjudication. And she believes she can be quite successful on deferred.
How old is your mother?
She was born in 75,
All right, how old are you?
25.
You shouldn't be hitting on your parents. You shouldn't be hitting on anyone. And honestly, I don't, because you have a previous conviction for assault, I don't even know why you should be trusted around children, honestly, because it appears that you have a temper. And that hasn't been sufficiently addressed because you're here for another assault. And it's another family assault. State, you wanted to add something because you came up?
I did want to add that we're just requesting that the evaluation is recommended by the state be actually done in custody.
Okay. All right. Is there anything else?
Judge, we would just ask to have the evaluation done out of custody.
When's the last time you had employment?
During my pregnancy, well, around this time, the incident,
Doing what?
my father's providing the rules for women.
All right, I can tell you right now, I don't allow people to be home healthcare providers for family members.
Well, I was looking for employment at fast food, honestly. And
Well, no. We start with what were you doing? And you said you were doing home health care providing work for your father. I don't allow this in this court. And to me, the home health care business is becoming akin to when we first started practicing, everybody was working at West Telemarketing. Now, home health care provider is West Telemarketing for felons. I don't allow people who are on felony probation to be home health care providers. They need to get a job. And home health care providers need to quit just looking at the bottom dollar where they're making a lot of money. Then they just hire random people to come in and watch people. Oh, you can watch them and we'll pay you $10 an hour. And then other things ended up happening. There's no way you should be in charge of caring for anybody because you have a temper that you cannot control. And how many children do you have?
Three living children,
I'm sorry?
3 living children.
All right. And what are their ages?
I have a 4-year-old, a 2-year, well, a 1-year-old, and then a 1-month-old.
And who are they with now?
Right now they're with dad's custody.
All right. What does that mean they're in dad's custody? Was there a hearing? He has legal custody, or you're just like, hey, I'm going to jail. Here you go.
Well, he's on the birth certificate and I'm incarcerated, so they stay with him and his mom due to my living situation with my mom.
All right. So that tells me that the grandmother's taking care of these children. I don't know why people continue to have children and then they want somebody else to take care of them. But I guarantee you, when these children graduate, when these children ended up being famous for whatever they've done, the parents who did not really care for them, they're going to be telling everybody on the planet, that's my baby. And you know what? Those children should say, no, I'm not. You didn't raise me. So in this court, you're not going to be allowed to be a home healthcare provider. All right, this is what the court is going to do. There's a $1,500 fine. That will be probated. 4 years deferred adjudication. Affirmative finding of family violence. There's to be no contact with Norma Casillas, Caslallas, and Tory, Tory Adams. There's to be no unsupervised contact with minors. Proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. And there's to be no employment in the healthcare field at all. So these schools where people go to and they're there for 3 months and they learn how to take blood, not allowed. You understand?
Yes, ma'am.
There's going to be 150 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 50 hours will be deemed satisfied. How far did you go in school?
I got my GD.
All right, what are you planning on doing with the rest of your life?
Honestly, working and taking care of my kids.
All right, I'm going to order, if she completes trade school, 100 hours to be deducted. I'm not requiring you to get a trade school certification, but if you do, 100 hours will be deducted. Otherwise, you're going to be picking up trash off the side of the road in the heat of San Antonio. HMAC, the Batters Intervention Program. TAP evaluation in custody. Follow Rex. Field visits 1 time per month until further notice. Regular reporting by Zoom or in person, and regular random UAs. Probation, is there anything else?
Judge, I just wanted to, the hostility management aggression control course. It is a form of the BIPP course.
Mhm.
Both of them do have, a good amount for,
Which do you think would be most appropriate for her?
the hostility management aggression control.
All right, so then I will not order the BIPP. Probation, is there anything else?
No,
Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Beating up your parent, never a good thing. If you feel as though your parent has not been the best of parents to you, you're an adult. That means that, you know what, mom, dad, you were not a parent to me. So I'm no longer going to have any contact with you. But to fight with your parent, that's a no-no. Think about it. What if one of your children were to start beating you up? It's not a good thing. You need to watch the movie called Imitation of Life. It's not so much about her being physically abusive to her mom, but she was emotionally abusive to her mom. Then when her mom dies, guess what? She is running down the street, crying, telling everybody who will listen, that's her mom. We only have our parents for a small window on this planet. And trust me, if your parents are here till they're 100, it's still never enough time. So you're going to have to change your ways. You understand? All right, good luck to you.
Thank you, Judge.
Thank you.
Before they both leave.
Yes. Yes.
one, sir, over one.
That's for second visit, yes.
All right, thank you.
Same incident, Judge.
And Ashley, I believe my song today is Don't Stop Me Now by Queen.
Oh, okay.
That song is very joyful. All right. So there was a bond forfeiture on this case that was issued because you did not appear for court. And that happened yesterday.
That's correct, Judge. I was made aware of the facts and circumstances as to Mr. Maldonado's non-appearance. I was here in the morning. However, it's my understanding he showed up at 1:00 p.m.
Mhm.
I believe during some portions of the jury selection.
Yes.
After,
Counsel, let's go on the record.
okay, yes, sir.
All right. Court is calling 2024 CR 011521 State of Texas versus Ruben Maldonado Jr. Can I have parties announced for the record for the state
Megan Galloway for the state.
defense?
Renee Munoz on behalf of Mr. Maldonado.
And are you Mr. Maldonado? All right. So yesterday he was scheduled to appear at 9 a.m. He was not here at 9:40. And then I do remember your client showing up sometime in the afternoon. I don't know specifically what time, but I know it was after our lunch break.
Yes, sir.
And so, I'm sorry, just one moment. This is the judge.
Oh, Your Honor.
Hello, Judge. All right. So, Mr. Maldonado, if you want to raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Ruben Maldonado.
All right, so is there a reason why you were late?
My father passed away.
All right. Okay, so here's the thing. When these things happen, you need to let your attorney know and you need to let the court know. Because if you would have informed the court of what was going on, then I would have known that you had a good reason for not being present and I never would have issued a warrant for you. And I don't think the state would have asked for a warrant to be issued for you if you would have kept us informed on what was going on, okay? I'm sorry about your father's passing. Defense, what are you requesting?
Your Honor, we reached out to the bond company. They're perfectly fine with staying on the bond.
Okay.
We're requesting that the bond be reinstated to that amount of $7,500, which she does have a good bond with the bond company, just if it could be reflected in the system, and to recall the warrant respectfully, Judge, she was in custody yesterday, and he sees the error of his ways, and I went over the issue of communication, how that is key in this court and every other court in dealing with a serious felony matter. And he understands that, and the sure is not going to be an issue. And in reference to the case, Judge, I did review the evidence. My client wants me to review it with him, but if we could be set for a plea bargain deadline, if the court is allowing him to be released on bond, a plea bargain deadline for next setting, I think we'll be able to move through this case.
All right, state any objections to the court recalling the warrant and reinstating the bond?
No, Judge.
All right, that will be granted. They'll probably release you from custody sometime at midnight. All right, I have no control over when they release you. You understand? All right. How much time are you asking for a plea deadline date, counsel?
I would say perhaps 3 to 4 weeks so I can show him the evidence and we can make a decision.
All right, Ms. Ferguson, if you can give me a 1-month reset for plea deadline date, please.
I can do the 15th of April.
Perfect.
All right, so we'll come back on April 15th. She's going to give you the reset form. And if there is some sort of an emergency, you need to let your attorney know and let the court know, okay? All right, thank you. You're welcome. All right, Robert Maurer, your client?
Yes, he's present, Judge.
Right. Let me just put this in the system. That's done. If you can make sure the warrant is recalled on that. And on this case, what case number were we proceeding on? Was it the 12230?
Yes, Judge.
All right, court is calling 2024 CR 012230, State versus Raymond McKinney. If you can come down, sir. All right, you're Mr. McKinney?
Yes, ma'am.
All right, and Mr. Maurer?
Yes, Judge.
Okay. We completed jury selection yesterday, and at that time, the court informed the jurors that trial would be starting at 9:30, and I ordered that attorneys be here at 9 a.m. for any motions to suppress that were to be heard. Yesterday afternoon, the state informed me, and I let the defense attorney know, so there will be no ex parte, that their witness could not be present till 2 p.m. I informed the state that the jury had already been told to be here at 9:30. If the court would have known beforehand that their witness would not be available till 2, I would have said, all right, we'll start the testimony at 2 p.m. My understanding from state, and correct me if I'm wrong, state, the reason for your witness wanting to be here at 2 is because he had something else scheduled with his employment.
That is correct, Judge.
Right. And I informed the defense of this matter, but I informed the state their witness needed to be here at 9 for the motion to suppress, and we were going to start jury trial at 9:30. Since that has occurred, state, what new information do you have?
That the officer, Ramiro Ramos, went to this event at 6 a.m., experienced a medical episode that was described to me by Sergeant Pena as an elevated heart rate, that he was being evaluated. I learned additional information that the evaluation is complete, that he has been cleared and does not need to be hospitalized, and that he is on his way, although he is dehydrated and will be, in Sergeant Pena's words, a little tardy.
All right, so this was scheduled at 9:30.
Judge, I'm ready to go. I'd ask the court to grant it a mistrial and order the case dismissed. Since the jury wasn't sworn, I don't think the court has the authority to do an instructed verdict, but I think clearly the officer had no intention of complying with the court's order. And I'd ask the court to deny the continuance.
All right, just so the record is clear, the court, I don't think the officer was under subpoena, so the court did not order an officer to be here at a specific time, but at a specific time, the jury trial was to start, and that was to start at 9:30.
Correct.
So I want you all to take a seat. Deputy Laura, are the jurors here?
We're missing one person, Judge, the cat.
Okay. So what I'm going to do is the jurors are here. I am going to swear them in. Either your witness is going to be here or they're not going to be here. I think that would be fair to both sides.
Will the court allow me to present a motion to dismiss?
Yes,
Will the court excuse me to get it?
yes,
Thank you, Judge. May I approach?
yes. All right. Any objections to the court signing the motion to dismiss?
No, Judge.
And what I will say for the record is, state, there's no intention that you are going to refile this case, is there?
No, Judge.
All right. So I will sign the dismissal. All right. Then the next question, we have these other cases that are pending. What is happening with those cases?
The first set of cases, the June cases, I think my intention was to do a motion to suppress based upon the stop. But I think Mr. Edelman has looked at that one and we're in concurrence about the lack of reasonable suspicion.
Yes, I intend to dismiss that case.
All right. So if I can have that dismissal.
Do you happen to have the cause number?
I can get it.
Oh, is it the 2024 CR 0?
09238. That's the one you
That's
have?
what your client is saying.
Yeah, that's correct.
Pardon me, Judge, I need to look up the proper dismissal code.
Sure.
Judge, off the record, would it be proper for the court to let the jury know that the officer didn't show up?
Well, I'm going to talk to the jurors, and anyone who wishes to speak to the jurors may speak to the jurors. All right. And then we have remaining the case ending in 200. What is happening with that case?
We intend to go to trial on the judge.
All right.
We get a panel up?
Are you ready to proceed on trial today?
Unclear, Judge.
All right. If you'll check to see if you're ready to proceed on trial today for that. And if so, we'll have a panel called up.
Okay.
All right. But what I can tell you is I know the state was intending to go on this case. And so we'll see if they're ready, and then they'll make whatever motion they want to make. If they're not, and I'll entertain that motion.
I guess, you gonna bring the jury in first or you want me to?
Oh, no, I just go and talk to them in the
Okay.
back.
Okay, I guess, just text me, let me know if I need to come back. I'll go reset some other stuff.
All right. Deputy Laura.
We're still missing the jury judge.
All right. I'll go back there and talk to them so they can enjoy the rest of their day.
Yell at the other person for showing.
You waited to get.
They need excuses. So I tell you what, come back. If you're back at 12, you can speak to the jurors as well. All right. And sir, if you'll have a seat in the box, we're going to see about this case. And Megan, I'm just waiting for your client to zoom back in. Well, I tell you what, your client was here on time. We're going to wait for your client. I shouldn't say your client, your witness. You know, every place you go now, they always say client. Even when you go to the Disney store, it's like, hi, welcome, our guest. All right, we'll wait. Yes,
Judge,
yes.
here, Mr. Maris Villarreal. And we have a partial agreement subject to complainant witness approval.
Okay.
And we're waiting for the phone call. Can we recall it for tomorrow because she hasn't called you?
All
yet?
right, who is your client?
Villarreal,
Could I see the file on Villarreal?
Maris Villarreal, Maris.
And who is the attorney for Jose Maciel?
Oh,
Thank you. Deputy Mejia. Make sure that McKinney doesn't go all the way back. We'll need him back. So once yes. So once he gets that done, just have him come back. Jenna, somebody already put it up here on the desk for me. It was hiding under a pile of things. All right, so is your client on bond?
Say that again?
Is he on bond?
No, he's in custody, Judge.
All right, so where is he?
He's in the back.
All right, so we'll just wait for them to bring him out.
As an update for the court, we just got word the victims in the new case that we're trying to get hold of are actually children. And they're in school, and that's why we
Okay.
haven't been able to get hold of them. So it's gonna have to be until obviously they can get out. So that's why if it's okay, it'd be better if we recall this to tomorrow.
No. I'm inclined to recall it.
Thank you.
I just want his client out and we'll discuss. So if you all can confirm, and if you could figure out if that's a good time for the witnesses you have, if you all would discuss that, and then we'll have your client brought out. All right. Sure.
Right, but anyway, I tried to like dumb it down for both of us. So that you can look at something and know where it's going, and then I'll show you on there how you can go to like file app and it pulls up like a whole where it is in the phone. And it's like You know what I mean? So it's not like anything, some of them are, but like, so anyway, I tried to like, do like, tell you right.
Hello.
Can I slip this to you?
Sure.
Your convenience.
All right,
But
thank
yeah,
you.
so Monday, time. The only
Yes.
reason I say that.
Yes. And so we'll have him back as soon as he's finished.
Alright.
Hi.
To school with Judge Wow.
Ah,
Took her next door.
oh, okay, awesome. Hi, guys.
Good morning, Judge.
Good morning. How are you doing?
Doing well. Can I approach real fast?
Yes.
We just wanted to hand this to you, invite you to our graduation. We have actually there's two letters in there for you.
Yeah.
Two graduates out of your court.
All right, and I'm opening this up without a letter opener. My mom would be very upset. with me. I love the letters.
One of them is I was actually very proud of him how well he wrote it. It was very good for him.
It's April 23rd. I'm not gonna be here.
No.
I know, but I'm gonna write them a letter.
Absolutely.
The only reason why I'm not gonna be here is because my mom's birthday
Oh, nice.
is April 22nd. So
Oh, wow.
I spend it with her. But but this is so awesome. I am definitely gonna write them both a letter back.
Absolutely.
But thank you all so
Oh,
much.
Of course.
No,
Have a good
otherwise
one,
I
Judge.
would love to be there. If y'all are live streaming it, I will definitely watch.
I'll let you know for sure. I know we've talked about it, and if we
Mhm.
go ahead and get that set up, we'll definitely make sure that you have the link.
Okay,
you,
awesome. Thank you.
Go all the streets of Kitchener.
Are you wanting my input on this? Is that why I'm here?
Let me see.
Okay.
Yes.
This way, they can turn on this side.
Yes,
Okay.
that's why.
I would probably need more information.
Okay,
Like, what is his proposed, like, what is?
all right. Well, I'll set it.
Me.
Okay, I'll set it for a hearing.
Okay, I think Danny De La Garza was he's not very informed. 'Cause
Okay.
I guess that would just be my only.
Okay. All righty, I'll have them set it for hearing. All right, thanks. Have a good one.
Good show.
And I will give you the other in just a moment. All right, do you all have a specific time for Mr. Villarreal? Have you been able to reach out?
Oh, for tomorrow?
Yeah.
Mhm.
So.
So,
Never. is good.
I mean, is it best to hear it in the morning, in the afternoon? Will you have some information by that time?
Well, the issue is we have to wait until this afternoon, obviously to call the victims, and just make sure they're okay with that proposed offer, and if it is, I think we can probably just resolve it tomorrow anytime. Should it need to be contested, I would think it has to be in the afternoon.
All right, so let's do this. We're gonna recall this for tomorrow, and we'll set it at 1:30.
1:30.
Yes,
Thank you, Your Honor.
you're welcome.
Maybe excuse.
Yes. Vashon, Villarreal, defense. If it is a contested, will you agree to have witnesses by Zoom?
No.
All right. Then,
I don't expect to be contested here at all. I think we have good agreement and.
all right, when I say witnesses by Zoom, I don't mean witnesses that will necessarily prove up the allegations within the motion. I mean probation officer.
Oh, probation, that's fine.
All right, so Vashon, if it turns into a contested, probation can appear by Zoom, but they don't believe it will be a contested.
Yes, I think we have good chance to resolve this tomorrow.
All right,
Yeah, the probation, yeah, definitely. Thank you. Judge.
okay, sure. Norma Villarreal, if you can put it on the docket for tomorrow afternoon. All right, good afternoon, everyone. All right, your reaction time is very slow, non-existent. So we're going to pretend like I never said anything. Good afternoon, everyone. Hi. All right, so you are here in the 187th District Court. You are on the 4th floor and I am Judge Boyd. So what floor are we on? And what's the court number? And who's the judge? All right, now I know what you're probably saying. We've been standing outside. We know where we are. But I always have to ask that question. And the reason why I ask that question is because sometimes we may end up taking breaks. And whenever we take a break, everyone has to leave the courtroom. And it never fails that when everyone leaves the courtroom, somebody goes missing and they will say, I looked up, everyone was gone. I didn't know where I needed to be. So there is only one 187 District Court in all of Texas. So if you are lost and you just say 187th, people will know. And there is only one Judge Boyd in this courthouse. So if you just say Judge Boyd, people will know where to direct you. So to my left is the court reporter. She takes down everything that everyone says. So the level that I'm speaking, the pace that I'm speaking, please do that. That will make her job easier. Please let it just be one person speaking at a time. Does everyone understand? All right. So I want you all to raise something that is in your possession. They are very expensive. They are cards with numbers on them. I see some people may have sat on them. They didn't realize how expensive they were. All right. So if everyone will please raise your card. Do not lower your card until I tell you to lower your card. Jurors 1 through 21, lower your card. Everyone else that has a card remaining, I'm going to give you an instruction. We're usually in this court in jury trial every week. So far, not a single jury has been able to follow this instruction. And I'm going to tell you what I told them. I have faith in this jury. I look at you and I say, they are going to follow this instruction. Here's the instruction. If you still have your card up, what that means is that whenever you are answering a question, please stand if you're able to stand. Will you all be able to do that?
Yes.
All right, I have faith that you can do that. You can lower your card. Now I'm going to have the parties introduce themselves for the state.
Andrew Harris Edelman, my co-counsel who's not yet present is Megan Galloway.
Defense.
Robert Maurer.
Trey Maurer.
All right, so you have all had a chance to see those parties. As state says, Ms. Galloway will be down here shortly. But for the persons who are present and the names that have been introduced to you, if you know any of those parties or recognize any of those parties, please raise your card. And does anyone recognize Ms. Galloway? If you can introduce yourself to the jurors, please.
Megan Galloway for the state. Apologies for being.
Does anyone recognize her? Now, the charge in this case is unlawful possession of a firearm by a felon. I'm going to talk to you about that in a little bit. But for now, what I want you to know is when I speak to you, when the state or the defense speaks to you, they're going to be talking to you in hypotheticals. They are not allowed to tell you what they think the facts are in this case. The only way you will know what people think the facts are in this case is if you are on the jury. Does everyone understand? So do not be a Mrs. Kravitz from Bewitched trying to decipher what the facts are in this case, because neither side is allowed to tell you. So they're just going to speak to you in hypotheticals. Now, how does a case come to felony court, a felony criminal court? It's here by way of indictment. What is an indictment? An indictment is a piece of paper that tells somebody what they're being accused of and where they need to be for trial. Does everyone understand? It is not evidence of guilt. It is not evidence of anything. It is just for the person accused so they'll know what they're being charged with. For example, we're going to practice raising our cards. How many people here have ever had a traffic ticket? And again, San Antonio continues to be a place where we have horrible drivers, but that's okay. So I've had a traffic ticket before once in my life. I think I was about 18 or 19, so that's been a year ago. Now, when I received that ticket, it was during the time frame where the officers would tear off a sheet of paper and they had a carbon copy, so they kept one and you got the copy. Now I think they do something electronically. Let's say an officer pulls you over and they give you a ticket and they say somebody's in the hallway doing something. Let's say they give you a traffic ticket and the traffic ticket, they say that you ran a stop sign. you get that traffic ticket. When you accept that traffic ticket, you're not saying, you're right, I ran this stop sign. The only thing you're acknowledging is that an officer is giving you a ticket and they're telling you they believe you ran a stop sign. And on that ticket, it'll tell you where you need to go to answer for that. And usually in Bexar County, it's the municipal court on Frio. You are not allowed to consider the fact that Mr. McKinney has been indicted for any reason whatsoever. It's not evidence of anything. It is just for him to know what he's been accused of. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. McKinney because he's been indicted in this case? Next, I want to talk to you about the right to remain silent. Everybody has a right to remain silent. What does that mean? You don't have to testify if you don't want to testify. I've been a defense attorney. I've been a prosecutor. Sometimes I would have clients, I would tell them, you don't need to testify. State didn't prove their case. What possibly you could say? There's nothing for you to say. They didn't prove their case. Other times I would have clients, they would be so terrified to testify because if you can imagine, you're sitting on a stand, everybody's looking at you. There are other clients I had who had different speech impediments and they just didn't feel comfortable. But everyone has a right to remain silent and you cannot hold it against them. Now, what I can tell you is sometimes people in the public will say, well, if that were me and it were my case, I would get on the witness stand. That's easy to say because that's not you and it's not your case. And you don't have an attorney who's maybe giving you advice. So the question is this. If Mr. McKinney decides not to testify, you can't hold it against him. You can't, if you're on the jury, be in the back deliberating and say, well, he should have testified, so that's a point against him. You're not allowed to consider it whatsoever. Does everyone understand? Yes. Is there anyone who's going to hold it against Mr. McKinney if he decides not to testify? Right. The next thing I want to talk to you is presumption of innocence. Everybody is presumed to be innocent of whatever they're accused of, unless and until the state proves its case, each and every element beyond a reasonable doubt. So the state would have to present evidence and you would have to believe that beyond reasonable doubt. Does everyone understand? So right now, what evidence has the state presented to you in this case? So if you had to vote right now on whether Mr. McKinney is guilty or not guilty, what should your vote be? All right, the people in the back are, I want everybody to be awake. So I'm going to ask that question again. If you had to vote right now on whether Mr. McKinney is guilty or not guilty, what should your vote be right now? All right. So is there anyone here who is not able to presume Mr. McKinney innocent? All right. Now, the burden of proof. Let's talk about burden of proof. What is it? I told you it's proof beyond a reasonable doubt. When I was in law school, there was a definition. You had to know it forward and backwards. I knew it forwards and backwards. I had my first trial. I knew where the commas were so I could pause. I knew where the exclamation points were, and I knew where to pause and let silence sit there for dramatic effect. Like now. Now what I can tell you is there is no legal definition for proof beyond a reasonable doubt. So neither attorney can tell you what it is because we don't have a definition. So I would always tell jurors what it was not to make sure that they're always at the correct level when they are deliberating. Next door, the courthouse with the green rooftop, that's where they try civil cases, your family law cases, your car accident cases. Over there, they have two burdens. One is preponderance of the evidence. What is that? That's more likely than not something happened. If ever you're on a criminal jury, whether it's in misdemeanor court or felony court, and you're deliberating, and you or one of the jurors says, you know what, I think this happened more likely than not, You are not at the correct burden for a criminal case. Does everyone understand? So there should not be any, I think more likely than not, somebody committed an offense. It's supposed to be proof beyond a reasonable doubt. Does everyone understand?
Yes.
The other burden they have over there is what's called clear and convincing evidence. Clear and convincing evidence is what is used to determine that you should not be a parent to your child, that you harmed your child, you're a danger to your child. I think everybody would agree that that's a high burden for someone to take your children away and say, you're not a good parent, we can't trust you with your child. That is their highest burden. There's a burden that's higher than that burden, and that burden is proof beyond a reasonable doubt. Does everyone understand?